Thank you very much, Diego, and thank you to Asil. It's nice to be back, and once again, as a medical doctor, I will expose myself to the danger of being in a room full of high-level legal experts. But I survived the last time, so I hope I will survive this time as well. It's my pleasure to introduce the panelists. I'll take them in alphabetic order, starting with Mr. Álvaro Botero, who is a member and rapporteur of the UN Committee on the Protection of the Rights of All Migrant Workers and Members of Their Families, in short CMW. And he is the coordinator of human rights monitoring and the rapporteurship on the rights of migrants at the Inter-American Commission on Human Rights. He is also an adjunct professor of refugee law at the LLM in International Human Rights Law and International Humanitarian Law of the Academy on Human Rights and Humanitarian Law on the Washington College of Law at the American University in Washington. We are also joined by Ms. Maria Clara Galvis, who is Vice Chair of the Committee Against Enforced Disappearances, CED, and Professor of International Human Rights Law at Universidad Externado in Colombia. She has worked as senior lawyer for the Center of Justice and International Law and as a senior consultant for the Due Process of Law Foundation. In Columbus, she has worked as an advisor for the Attorney General and the Prosecutor General, as well as an assistant judge at the Constitutional Court and the High Council of the Judiciary. She has represented victims of human rights violations before the Inter-American system and has conducted research and published articles in the fields of inter-American law, transitional justice, rights of victims, indigenous people, among others. And last but not least, we have Ms. Hélène Tigroutiat, who is a member of the Human Rights Committee and professor of international public law in France, Aix-en-Provence, an independent expert in the Human Rights Committee. Her field of research are women's rights, rights of victims, including right to remedies, rights in times of emergency, among others. She also works extensively on the conciliation and articulation between UN human rights mechanisms and regional human rights systems. Her commentary on the American Convention on Human Rights, written with Professor Annabel from Belgium, will be published by the end of 2019 by Oxford University Press. We're looking forward to that. Today we are talking about the treaty body system, if we can call it a system. It has developed over the last 50 years, starting with the CERT, the Convention on the Elimination of Racial Discrimination, in 1969. And now we have 10 human rights treaties. They are all legally binding treaties. They are endorsed by the UN General Assembly and ratified by states. And of course, this distinguishes this system from the special procedures, which is decided by the Human Rights Council. The more recent conventions differ from the earlier ones in many ways. For instance, in terms of the review cycle for country reviews, in terms of the number of terms of office that members can actually be elected for, the number of members in the committee, the presence or absence of individual complaints and inquiry procedures. These are not the same over the 10 treaties and treaty bodies. Further than that, the treaty bodies themselves decide their rules of procedure, and this has not necessarily been coordinated very strongly over the years. So in fact, we have a rather heterogeneous system. In 2014, the United Nations General Assembly adopted the Resolution 68-268, which introduced a review of the treaty body system to take place in 2020. The resolution also introduced a formula for allocation of resources to the treaty bodies, depending on the number of state party reports and individual communications that each committee had, so that there was an automatism between the workload of the committee and the allocation of time where the committee could meet, and in conference services, including the interpreters. But already in 2018, there was a mismatch with the secretarial support, because the secretarial support is not included in this automatic mechanism, and when the OHCHR, the High Commissioner's Office, applied for more resources to match the increased time by the committees, they only got a fraction of what they asked for, with the result that the Secretariat is unable to prepare the number of cases in the backlog that the committees are supposed to deal with. Currently, the treaty bodies are preparing for the 2020 review, and we have attempted over the years, at the encouragement of the General Assembly and Member States, to align procedures and working methods a bit more, and even more to project a vision for how the system should work in the future. Later this month, the chairs of the 10 treaty bodies will meet in New York, and we will attempt to finalize a common position to be communicated to the General Assembly. An emphasis here will be on strengthening the treaty bodies in terms of increased implementation of the conventions and higher compliance with the reporting obligations. I don't think it's a secret that during this discussion you could almost consider this process as a treaty body weakening process, because resources have been scarce, member states have reporting fatigue and wants to be relieved, and they want to save money on the system that is considered as a linear growth system. And in the meantime, the UN budget crisis recently hit the treaty bodies. The High Commissioner for Human Rights informed the treaty bodies on 30th of April this year that there might be a cancellation of the third session for those 6 treaty bodies who have 3 sessions in 2019. This would be an unprecedented undermining of the treaty body system and make us subject to budget fluctuations in the UN in spite of the legal basis that we're working on. So this is more or less the scenario of the treaty body system these days, and it's my pleasure to give the floor to Mr. Alvaro Botero from the CMW. Alvaro, the floor is yours.
Thank you, Jens. First of all, I want to thank the American Society of International Law and the Academy of Human Rights Law and Humanitarian Law for the invitation and to be part with all you in this panel. I will address some of the developments that have been made by the Committee on the Protection of Migrant Workers in recent years, why the committee is still relevant considering the recent adoption of the Global Compact on Migration. Well, as you know, the convention was adopted in 1990, and it took a long time for this convention to finally enter into force. It was a process that took almost 13 years for the convention to enter into force. And at this moment, the convention is one of those 10 legal instruments from the UN system with the lowest number of ratifications. Just 54 states has ratified the Convention for the Protection of Migrant Workers. And we haven't had any action from 131 states of the United Nations. 13 other states has taken recent actions in order to consider the ratification of this convention. So this might seem like a very discouraging point in relation to the importance of this convention, but even considering that background and the long time that it has taken for the states to ratify the convention, there has been very interesting developments coming from the committee in recent years. And especially through the use of its mandate, like, for example, with the adoption of concluding observations, like the one on Guatemala or Libya very recently, or joint general comments like the one that the committee adopted in 2014 with the Committee on the Rights of the Child. In this context, and also considering all the resistance that there is from the states to adopt or to establish more rights for migrants or to consider migrants as subjects of human rights, it might seem tricky or challenging for the states to consider the ratification of the convention now that they have this framework that provides them the Global Compact on Migration. But some of the main advantages of the Convention on the Protection of All Migrant Workers and Their Families is that this is the only instrument that is legally binding at the universal level. On the other hand, it's the only instrument, even when all the other treaties apply for migrants too, but this has specific provisions for the protection of migrants and also address all the stages of migration. So it gives protection to migrants in their countries of origin, in countries of transit, destination, and also in return processes. On the other hand, as I was mentioning, through its regular functions like concluding observations or general comments, the committee has taken a very, we can say, a progressive role in interpreting the convention, and through its general comments has tried to address new issues that has been appearing recently, like, for example, the disappearance of migrants and not necessarily forced disappearance of migrants, or the impact of bilateral or multilateral agreements in the respect of the rights of migrants. On the other hand, there's a lot of misinformation or misunderstanding about what the convention really establishes and what are the duties that impose to states parties of the convention. And there's a specific part, the sixth part of the convention, that address forms of cooperation for the states in order to address migratory movements, which is part C of the convention. In the committee, we think that an harmonious interpretation of this part of the convention with the Global Compact of Migration might have a broader space for the articulation of these two instruments, the convention and the Global Compact. In terms of the general comments, so far the committee has adopted 4 general comments. The first general comment was specifically addressing the situation of migrant domestic workers, which is a term or a category that was not particularly recognized at the convention. The second general comment specifically deals with the vulnerability of migrants in an irregular situation and the protection that states should take in relation to this. But for me, the most interesting development in terms of the general comments that the committee has adopted is general comments number 3 and number 4. What is very interesting about these 2 general comments is that they were adopted with the Committee on the Rights of the Child. So what this allows at the end for a committee like the Committee on the Rights of Migrant Workers, which just have 54 member states, was through the standards developed in these 2 general comments, expand the protection for migrant workers and their family, considering that the Convention on the Rights of the Child has basically universal applicability because just the United States is the only state that hasn't ratified the convention. So I think there's a lot of space or room in terms of opportunities for the committee, and that's what we are trying to do for the next general comments that the committee will be adopting, to try to do this joint general comments with other committees in order to expand the protection of migrant workers. And the next general comment, for those who might be interested, and it might also be an opportunity to work together with the committee, with the Human Rights Committee, or also with the GATT, will be dealing with the protection of migrant workers when they are deprived of their liberty. So we'll be specifically addressing the protections under Article 16, which is one of the main challenges that we are seeing nowadays, considering the increase of the use of immigration detention and other forms of deprivation of liberty. My last points will relate to concluding observations. For example, the concluding observations that the committee adopted in relation to Guatemala. And there was something very interesting in these concluding observations because at the time that we were reviewing Guatemala, United States adopted or subscribed a bilateral memo with Guatemala in order to try to deter the migration from Guatemalans and Central Americans to United States, especially considering the phenomenon of the migrant caravans. What it was very interesting in relation to this agreement that was subscribed between Guatemala and United States was, even considering that the United States is not party of the convention, Guatemala has the duty to guarantee that the agreement is in line with all the provisions of the convention. So if this bilateral agreement with the US is in contravention with any of the provision of the convention, that will entail international responsibility for Guatemala, and at some point will make the agreement void. Another point that I would like to mention in relation to concluding observations, it's in relation to the concluding observations on Libya. Well, as you know, the situation in Libya is very problematic at the moment. There are basically two ruling powers in the country. There's an internal armed conflict in the country, and there are agreements with the European Union for the devolution or the return of migrants who are intercepted at sea. So again, addressing the issue of bilateral agreements, basically what the committee said is these returns to a place like Libya where there is enough evidence about mass torture, disappearance of migrants, human trafficking, might also contravene not just the provisions of the convention, but at some point might also be a contravention of international criminal law. So it's very interesting because we can see that there is a movement that has also been led by other committees of the UN, like the CAT or other committees, in trying to make this connection not just between gross human rights violation, but also that at some points gross human rights violation might be international crime. So I will leave it here, and I'll be happy to address your questions at the end. Thank you.
Thank you very much. I think it's very impressive how CMW have managed to extend their protection of migrant workers in spite of a very small number of ratifications through constructive collaboration with other committees. Yes. I give the floor now to the second panelist, Ms. Maria Clara Galvis from SED.
Thank you, Jens. I will approach from a different point of view, and I will talk about the committee when I will talk about other issues. First, I would like to say something that maybe it's obvious, but it is worth to mention, is that the achievement, it's an achievement itself, that we have to be proud of this great development after the first convention, the Convention on the Elimination of Racial Discrimination. I think that the drafters of that convention and also the drafters of the two conventions, the one on economic and social and cultural rights and the one on civil and political rights, then at the end of the 60s, beginning of the 70s, I don't think that anybody then can imagine that now, 4 decades after, we have such a great development, like views, general comments, concluding observations, reports of visit to countries. So if you see, that is a huge amount of recommendations and of evaluating the obligations of states. And the success of that now gets to a point that we have a lot of those things and 10 committees working, and I understand that resolution 268 is like, okay, let's stop, reflect, and organize in a better way to strengthen. And I will highlight some things that I think are important in order to have a better protection of all citizens of the world by the treaty body system. And the first is something that is also obvious, which is the need of universalization. If you see, there are 10 treaties, but not all states have ratified all the 10 treaties. So an idea of universalization would be having all the states that are member of the United Nations to have all the treaties ratified, and also to accept the competence of the committees to file, to have cases, either individual communications and communications between states, because I think that that's the goal, and that's the idea that we should walk towards that. Because here we are people from different nationalities, and under international law we have different protections, because sovereign decisions of our countries that have decided to ratify 1 or 2 treaties or 3, or ratify the treaty but not ratify the full competence of the committees. So I think that the first challenge would be universalization. And maybe you can think that that is on the state, because states ratify. But I think that some things could be done from the system and from the UN. For example, the special procedures, when there is the universal periodic review, some states recommend the states to ratify. For example, Japan, and I think that that is completely true, Japan has told our committee that Japan recommends in the UPR states that haven't ratified the Convention for the Protection of All Persons Against Enforced Disappearance. At the UPR, they recommend to ratify our convention. So that's something that can be done in order to universalization from the UPR, from the special procedures system. And also the bodies, my committee launched a campaign, because it's also one that has little ratifications. Now we have 59 states that are parties of the convention, but 2 years ago, in 2017, there was 57 states, and a campaign was launched in order to have 112 ratifications by 2022. So that's something that was put there by the committee in order to advance in this universalization. There's a lot that we can talk about universalization, but I will leave it that way, and then I will mention another challenge. I think that strong protection of human rights of all persons needs something that may be obvious, but that the members of the committees are really experts and really independent. And unfortunately, that is not always the case. So the international community, the states, civil society has to work and have experts, people that know about human rights, that have some expertise in human rights, and very important that they are independent and impartial when taking decisions, and independent from the governments. And here, I think the situation of the lack of transparency of the process of nominating and electing members is worse than at the inter-American level. Because at the inter-American level, civil society is organized, there's a sort of discussion. Maybe some of the persons that are here heard that last week there was the final report of a panel. Here we have one of the members of that panel, and it's a panel of civil society, but evaluates the candidates, the knowledge of human rights, and the independence. At the UN, at the treaty body system, there's nothing. There's no civil society saying that this candidate or this person is not an expert or is not independent. So the process is very opaque, very dark, very obscure.
Untransparent.
So again, this is something that you can say, okay, call on states to nominate really experts and really independent people, but I think that there's something that can be done from the treaty body systems and from the civil society. The chairs, there's a meeting, a yearly meeting that James was talking about. Every year, the chairs of every committee meet, and in 2011 they adopted the Addis Ababa guidelines, which are adopted by the members of the treaty bodies and are supposed to be followed by those members. But that's not the case. We were talking about a case that is public. I mean, there's a lot of independent experts that, besides the work at the committee, they are also ambassadors of their countries to another country or to the European Union. So that's not, I mean, and they could be good members. They could be, they can have a knowledge of human rights, and they can also be very good as chairs. But when you have two positions, independent expert, and at the same time you are the ambassador of your country, that doesn't look as very independent. So the first thing that I think is that the experts, the members, should abide by those Addis Ababa guidelines and respect those guidelines that they adopted. And there's also something that could be done from civil society. The expert panels, I think that this experience of the Inter-American system that is already 5 years, I guess, could be exported to the United system and had a sort of a panel of independent experts that evaluate the independence of the candidates. Something has been done by the GQUAL campaign, which is an initiative to have gender parity. I think that that is part, and that is something interesting and important, but only focuses on gender parity. And I think that something needs to be done on the independence and impartiality of the candidates. That's what I see. That's a second challenge, which is the have more transparent and participatory process of nomination of election. And there's another challenge, which is a challenge of every international protection system, which is the implementation of the decisions. You can have all this amount of views, concluding observations, reports, but if states don't implement and don't comply with this, we don't achieve the final goal, which is protecting every citizen from violations. And in this, I think that things can be done in the states, I mean, by the states, but I think a special thing or something important can be done in the working of the committees in having more close relations with national human rights institutions, the so-called Defensorías del Pueblo, comisiones, human rights commissions, the national human rights institution, because the national human rights institution are the bodies that in each country can implement and can disseminate and all these decisions that the committees make. But there's also something that can be done by the treaty body system, by all the committees, which is something that at the UN is done, in my opinion, very widely, which is have a better communication system. Yeah, I mean, there's a lot of interesting views, a lot of interesting concluding observations, but sometimes they go unnoticed. I have to call the colleagues of other committees when I have to teach a class, or, hey, what have you decided about this and this? And I think that in the era of communications, I think that something could be easily done to have better communication of what the committees are doing. And in that, for improving in the implementation, I think that there's also something that has been done at the Inter-American system that can be made at the UN level, which is having sessions out of Geneva. I think that many years ago, when the Commission and the Inter-American Court began to have sessions out of Costa Rica and out of Washington, that was a very important way to have, so these organs have more visibility. Because if the session is in Geneva and you don't know what's going on in Geneva when a committee is in session, there's a lot of things going on at the same time. But if the committee goes to a country or to a region and have sessions there, that would give more visibility. The people can interact, and I think that is a good measure. And well, when you talk about, at least in my committee, when we have this discussion, there's always the issue of money. We don't have enough money to have a session outside. We need translation. We work in 3 languages, Spanish, French, and English. So you have to do a lot of things that cost. And yes, that's right. But we can start with something done by the offices of the High Commissioner in the countries. Mexico, for example, has an office of the the High Commissioner has an office in Mexico. When there is a session of, let's say, the Committee Against Torture, that last session has the review of Mexico, the High Commissioner in Mexico could have organized a meeting like this to, now that the sessions are webcasted, that would be like a first step to bring the sessions more close to the people. But the idea would be to have sessions outside, and I think that that is possible because, for example, the working group on enforced disappearance, of the 3 sessions that they have in the year, one of them is in Geneva, and the two others are out of Geneva, and they have the same issues of translating, of languages. So I think that the cost is something like an excuse because that can be done. Always we don't have money is an excuse, but we have to overcome that. And my last challenge is in this process that started with Resolution 268. One of the issues was the harmonization. Like, yes, you have 10 committees, but let's make them appear like a system. And I think that this is a good idea, it's a good objective. But at the same time, I think that the goal is to keep the autonomy of each one of the committees, for example, when they do things that no other committee does. For example, the Committee on Enforced Disappearance, I will only give 2 examples, has the measure of urgent actions. And that is something that no other committee has because the committee is in charge of this issue that is so serious, the enforced disappearance of people. The treaty in Article 30 has the urgent action mechanism that allows every person from a state that has ratified the convention to call the committee and ask to issue an urgent action and give the state not the order, well, ask the state to adopt measures in order to search and find a person that has been disappeared. And this mechanism, I think that, well, this mechanism, we have registered 775 urgent actions, which means that from the beginning of the committee, which was 2011, till now, 1,770 persons have requested the committee an urgent action measure. This is an example of something that in which the committee should have autonomy, because it's a measure that is only of this committee. So in this, no harmonization, but this is a simple case. But there's another one in which the Committee on Enforced Disappearance has a difference with the other committees, which is in the reporting. The convention is the only one that doesn't establish a periodic review. Under the convention, because there was this that James called, well, not you, but the reporting fatigue. States said, well, we have to report to 10 committees, and when the convention was adopted, there was in the ambience this kind of fatigue. Another committee to make another report. So the authors of the treaty decided to have only one report. And after a report of the country, the committee then has the possibility to evaluate if the committee asks a country to come back to Geneva to a dialogue. And the committee has evaluated until last sessions in April, 31 states. And of those 31 states, the committee has asked only one, Mexico, to come to a dialogue, a follow-up dialogue, which is not a periodic, but a follow-up, and it was focused only in the recommendations on the initial report, on the initial concluding observations. I think that this, that is particular from the committee, could be retained as a good practice for other committees that having this periodical, in practice they could adopt the practice of calling back. I know that the treaty says periodic, but calling only the states that have a problem with migrants or with torture. I know that every country has a problem, but there are countries that have more problems than others. So this, take this as a practice for the following, for the reporting process for other committees. And in the harmonization, I mean that with regard to the things that which a committee, at least mine, should keep autonomy, not harmonization with other committees. And with the things that can be fixed or that we can do better, Alvaro already talked about the joint general comments, but so I will not talk about that. I have one that is for the future, but now the Committee Against Torture already did it, which is a comment on the non-refoulement mechanism, and the Committee Against Torture and the Committee on Enforced Disappearance both have almost the same clause. The language is similar. A state cannot send a person when there's risk of torture and when there's risk of enforced disappearance. It could have been a good idea to have a comment together, but we can find, for example, similar obligations. For example, states have to put in the criminal legislation the crime of torture and also the crime of enforced disappearance. That could be a general comment on typification of both crimes. That could be something for the future that can be done jointly. And my last point is that the harmonization or the collaboration is not only between the committees but with the regional system. And last year, my committee and me, I think we did something that is a good practice, that the Inter-American Commission had a hearing in the region about organs or bodies at the national level that are in charge of the search of disappeared persons. And they invited me as a member of the Committee on Enforced Disappearance to have a joint hearing, because that is an issue that is important for the committee. By that time, we were at the committee preparing the guidelines on the search of the disappeared that were approved last April, and the hearing the participation in the hearing was very useful for that, for gathering information, and it was also good, I think, for making visible one of the committees at the UN here in the Inter-American system. So I will leave it there. I don't know if I took much time or not.
No, but you had important points, so it's justified. You dealt with universalization and with the independence and expertise of members, with the implementation and sessions out of Geneva, and with the harmonization, a word that the chairpersons actually don't really like. We use the word alignment, which is a little softer. There was just maybe one thing you didn't mention, but you could have mentioned, but you didn't have the time to do so, and that is the reporting compliance. Because as the system works now, a state can block its own review by not reporting. Because currently we only schedule reviews when we have received the report. And in my opinion, it should be the other way around, that we schedule the reviews according to the reporting cycle, and then we carry on with the review independently of whether there's a report or not. In CAT, we have several times done review in the absence of a report, and it works well. So that's another problem in the whole business of the treaty body system. Okay, I will give the floor to the last panelist, Ms. Hélène Tijoutier, from the Human Rights Committee.
Thank you very much, and thank you for the organization of this extraordinary panel. And I'm very pleased to hear colleagues, because I totally share your views. So I'm not going to repeat what Maria and Alvaro said, but I'm going to illustrate with the practice of the Human Rights Committee. So I'm a new member of the Human Rights Committee. So I had my first session in March, but I totally share all what you have done, and especially the challenges, etc. So I'm here to share with you, I would say, some provocative thoughts on the Human Rights Committee and the challenges I have identified as an academic, but also as a member. And I hope these challenges could be fixed in the future for the Human Rights Committee, because for me it's a question of legitimacy of this body. So just very briefly, I remind that the Human Rights Committee, as other treaty bodies, has three main missions. First mission of monitoring the implementation of the ICCPR by state parties, and we have not the same problem of ratification, of course, than the other committees, because there are 172 state parties to the ICCPR. So it's not universal, totally universal, but it's not that bad. And based on this process of monitoring, the Human Rights Committee does adopt concluding observations as other treaty bodies. The second mission of the but I'm not going to talk about this, and I share what you have said, but I'm not going to talk about this mission of the Human Rights Committee. The second one is that the Human Rights Committee does receive individual communication, but it's not a compulsory mechanism, as you have said. It's an optional mechanism. It's only this process is only available for people if the state has ratified the optional protocol, and by now there are 116 states that have ratified the optional protocol. So I'm going to say a word on this individual communication proceeding. And the third mission of the Human Rights Committee, as the other committees, is the adoption of general command, and it's a kind of general opinion, of advisory opinion. But the difference with, for instance, the Inter-American Court of Human Rights is that here the Human Rights Committee is not sized by a state or by an organ, and is not asked to answer to a precise question, but members of the committee decide to adopt a general comment on a provision of the ICCPR or a general question, general obligations of the states, etc. So last year in October 2018, the Human Rights Committee did adopt the General Comment 36 on the right to life, so I'm going to say a word on this. And the ongoing General Comment 37 is about Article 21 of the ICCPR, the right of peaceful assembly. So it's a very interesting process, and I'm going to say a word on this. So I'm not going to talk about the monitoring of states' application of the ICCPR. It's an important mission, but I'm not going to discuss about this, but about the two other missions of the Human Rights Committee. So first, a word on the general comment, and I totally share what Alvaro said on this. The process of adopting a general comment, it's a very interesting process. It's a fascinating process because, there's a kind of public discussion with civil society. So when there's an ongoing general comment, there's a call for submissions from the civil society, legal clinic, universities, individuals, states also. It's not exactly the same process as the International Law Commission. So there are no dialogues with states on the different drafts, etc. But it's very interesting because, of course, the general comment is supposed to adopt the different views and the different positions expressed by the civil society, by the states, and by members of the Human Rights Committee. But it may be a very long process. So the general comment on the right to life took 5 years to be adopted, and one of the main problems of this general, so it's a very long general comment. There are, I think, 70 paragraphs. But all the discussions were focused on one paragraph, and it's paragraph 8. And if you read paragraph 8, you will see that it's about abortion. And it took not 5 years, but almost 4 years and a half to write and to draft this paragraph, because members of the Human Rights Committee do not have the same position on abortion, and members of the committee, and that's also the current position of some members, do not agree with the adoption of vocabulary as sexual health or reproductive health. So, during four and a half years, the members of the Human Rights Committee really fought in order to adopt this paragraph 8 on the right to abortion. So it may be a very long process, and it was adopted before I entered into the committee. So now it's quieter because we talk about peaceful assemblies, so it's not, the passion is not as violent as when we talk about abortion. So we had a very calm session in March when the rapporteur expressed his views on peaceful assembly. But for me, there are two challenges in this process of general comment. And the first is that it's not really to know if the general command is legally binding or not. I think we can discuss about this, but for me it's not the main issue. The main issue is what, as members of the committee, we are ready to do with our own general command. And on this, and I shared my concern with colleagues in March, on this I have the impression that my colleagues, some of them suffer from schizophrenia, and I'm happy to be near a doctor to talk about schizophrenia. Because, I have the impression that they adopt general comment as a kind of theoretical discussion on the extension, the content of states' obligation. But when very concretely we talk about the application and the implementation of our general comment, members say, oh yeah, no, but it's more complicated, etc. We are not sure that we are going, etc., etc. And I'm going to take one example. In the general comment on the right to life, one of the good paragraphs is the paragraph on the the right to a life in dignity. And it's really taken from the case law of the Inter-American Court of Human Rights. So not only the right to be, not to be killed by the police, but the right to food, the right to a shelter, etc., etc. So it's a good step, and it's a good and it's a progressive step in the interpretation of the right to life. But when we receive based on individual complaint, and especially in case of deportation, when we receive cases of people who say, okay, I cannot be deported to Italy or cannot be deported to Afghanistan because I will have no money, I will live in the street, etc., we are not ready to accept this kind of complaint. So for me, there's a problem. There's a gap between what we say in our general comment and what we are ready to do when we receive in individual complaint. And we will have very soon a test on this, if we suffer really of schizophrenia or not, because maybe you have heard that 2 weeks ago, or maybe a little bit more, at the beginning of May, a community lodged a petition before the Human Rights Committee on climate change. And based on the right to life, but as interpreted in the general comment. So it's a petition against Australia, and the idea is to say that Australia has not respected its obligation under Article 6 of the ICCPR, the right to life, and Article 27, rights of communities. It's an indigenous community. So it will be a very interesting test if we are ready to apply these 5 years long general comment. So I think it's a problem. I mean, of course, we are academics, so it's funny to discuss from a theoretical point of view about the content of the right to life, but we are talking also about real stories and real problems. So the general comment are called to be applied. And the second element, I will be very brief because Alvaro mentioned this, and I totally agree. The second element on the general comment is that my committee is totally isolated from this movement. And this movement, the movement Alvaro mentioned, and the joint comments and the joint declarations, etc. And I really admire what you have done with the Committee on the Rights of the Child. And it's not only, I admire the move not only from a formal point of view, but the substance of the two joint declarations, joint general comments on the rights of children during migration is extraordinary. And there's really, it's not a formal idea to say, okay, we are going to adopt a joint text, but it's really good to see two expert organs working together in order to precise the state's obligation regarding rights of children during migration. And we really need this because we do not know everything. The ICCPR, it's an old treaty. The ICCPR is not a self-sufficient treaty. So we really need this more specialized analysis of problems, of issues. So I hope that in the future, and I have heard your call for a general comment, and I was jealous because you mentioned the Committee Against Torture and the Committee on Migration, but not my committee. And I hope we will have this kind of things because I really think that there's a plus-value in this way of discussing. And it's also a question of harmonization, building a system of human rights, etc. So I totally share your view on this. And also some concerns on the individual complaint procedures of before the Human Rights Committee. So as I have said, it's an optional process, so it's not a compulsory mechanism, and per year the committee does adopt more or less 100 views or decision of non-admissibility. And I have to say, to be honest, that regarding some issues, the case law of the Human Rights Committee is more progressive, for instance, than the case law of the European Court of Human Rights. So I'm not only, you know, I'm not, I criticize, of course, but there are good things in the work of the Human Rights Committee, and I see that it's recorded, so I have to say that there are really good things on the work of the Human Rights Committee regarding, for instance, rights of women or rights in times of emergency, etc., etc. But again, some challenges, and most of them have been mentioned by Maria, so I will be very brief, but many challenges in this practice of the Human Rights Committee adopting individual communication. And first, and I totally agree with what Maria said, first, diffusion and communication. Even as an academic, and even as member of the Human Rights Committee, it's totally impossible to find out a decision, to find something on the website. And it's really a problem. And I was also admiring the Twitter account of the Committee on Migrant Workers, but it's very helpful. I mean, it's the way, it's the mean I use to know, for instance, and to follow the work of your committee. But it's a disaster because some decisions are missing. So I have the reference of the decision, but they are not on the website. And sometimes they are, but they are only, for instance, in one language. The general comment on the right to life does not exist, only exists in English.
Yes.
Yeah. So I presented the general comment in Honduras and Peru last month, but it was only in English, and it's not acceptable because English is not the only language of the UN. So there's a real problem, and again, it's not only a formal problem or a theoretical problem or a problem for academics, but it's really a problem for the civil society, for the victims, etc., to have access to what we do. So when we adopt general command views, etc., it's not just for ourselves, it's not just for experts, and it's not supposed to stay in Geneva. It's supposed to be known by people, and it's really a disaster, and we complain, etc. But yeah, in general, the answer is the same. We do not have any money to fix this, etc. The second thing is about compliance, and we have the same problem that other committees. And, you know, there are different categories of we do not have a proper mechanism of compliance as the Inter-American Court of Human Rights or the European Court of Human Rights. So we just send the views to the state, and the state respond sometimes. It's not always the case, but the state may respond, and the state say, okay, we do not recognize you because you are not a tribunal, so we are not going to respect your views. Or sometimes it's for instance, the position of Australia, quite rude against the committee. Some other states are more polite, and they say, okay, we take this into consideration, thank you very much, etc., but we cannot respect for such reason, for domestic reason, etc., etc. And last year, we had a very tense, a very, very strong fight with, the committee had a very strong fight with France, and it's still ongoing dispute between the committee and France because of contradiction of jurisprudence. The Human Rights Committee did adopt 4 views regarding freedom of religion. And in these views, the Human Rights Committee concluded that the French legislation on wearing of religious scarf, etc., was contrary to the ICCPR. The problem was that in previous judgments, the European Court of Human Rights say to France, oh, no, your legislation is totally respectful of the European Convention of Human Rights. So for France, it's very easy. On the one side, there's a judgment, there's a binding decision. On the other side, there's the views from a committee with experts, not really independent, etc. We are not sure that they are skilled in human rights, etc. So we are going to respect the judgment of the European Court of Human Rights. So And the problem in the decision is that I think it was wrong from the Human Rights Committee. The Human Rights Committee didn't quote at all, and that's the problem of isolation. The Human Rights Committee didn't mention and didn't quote at all the case law of the European Court of Human Rights. And I think that it would have been better to be more not respectful of the case law of the European Court of Human Rights, but to say to France, okay, we know that there are two contradictory decisions, but maybe we will try to convince you that our position is the best. I really think in pedagogy, etc. So I think here it was a mistake to stay isolated. And my final point, and I will be very brief, is about this isolation problem. And I have the impression, and for a reason I can discuss during the time for Q&A, but I have the impression that the Human Rights Committee totally interpret the ICCPR in isolation, without knowing, being interested in what other treaty bodies do, what other special procedure that the Council of Human Rights do, what other regional organs do, for many reasons, historical reasons, etc., etc. But yeah, that's another problem. The optimistic note I would like to conclude with is that we have a new rules of procedure, and there's a provision. It's Rule 96, and it's good because Rule 96, it's a third intervention. It's an amicus curiae proceeding, and I have great hope in this kind of process, because it will, in this climate change case, for instance, and in other cases, it will bring the civil society in the litigation process, and it has done a wonderful result in the case law of the European Court of Human Rights, Inter-American Court. So I hope it will also, if we use it properly, I hope it will also improve the practice of the Human Rights Committee. Thank you very much.
Thank you very much. We have around 20 minutes left for Q&A. Not so much, but I think there's a lot of themes that have been touched upon here. One is, for instance, the ratification, where we have to think not only in universal ratification, but we also have to think about the capacity of the committees in case of full ratification. Because if we have 200 countries ratifying and we have a 4-year reporting cycle, everybody can calculate that we need to process 50 reports a year. Currently, CAT, who is one of the committees with rather extensive, we have 11 weeks, which is more than most. We process 16 a year. And this challenge means that we have to think innovatively. We have to think in other ways of processing those cases, because this will be an argument against us in the 2020 review. You cannot continue like you do now. It's too expensive and you don't even have the capacity. So for this reason in CAT, I'll just give one point of CAT abusing my moderator role here, and say that CAT has calculated we have 2 rapporteurs for each state party review. If we go to the regions, 2 by 2 by 2 by 2 by 2, we are 10 members in total, and we review 3 countries in a week's time. We have a break, we go back in plenary, and we conclude the concluding observations there. We will certainly, in one session, have reviewed 15. And that means 3 sessions, which we have, would actually allow us to review 45, which is very close to the 50 that we're required to do. So my point is just, we have to really think in terms of innovative ways of working if we want to influence the 2020 review in the General Assembly. That said, I'd like to open the floor. Questions, comments? Yes, please.
Well, first of all, thank you very much for your interesting presentation. I have a general question concerning the UN system on human rights or the Inter-American system of human rights. in relation to the migrants coming from crossing the Mexican, the U.S. border, and the situation they have once they come here, that they are taken away from their parents, and they have, so far, 6 have died already, and probably they are abused already. So do you have some information on that? I believe that there is something, and if there's some coordination of both systems, or I don't know, if you could elaborate a little bit more. Thank you.
Thank you very much. You asked?
And I have 2 questions. One for Ellen. Thank you. Whether you mentioned the discrepancy between decisions of the European Court and the committee. There has, over a long period of time, been talk about creating a UN Human Rights Court. Is that alive? Is anybody talking about it? Do you think it would be a good thing? And the question for Alvaro, I know nothing about migrant law, I admit. And I'm wondering, I remember when the Global Compact was approved, the speakers all said, it's nothing more than the ICCPR. It's what is out there already that we're affirming also applies to migrants in the world. In your convention, is there anything that is distinguishing? Is there a migrant right, any kind of migrant right? And are irregular or undocumented migrants specifically protected in any kind of way?
Thank you. Yes, over there, please.
Hi, thank you for the amazing panel. And you talk about the idea that the Commission can go to the countries to have a better contact with the civil society. And also, they have a lot of good information, good decisions in the communities, but the civil society in general doesn't know how work the ONU organization and the committees. So how you think the ONU organization, the community, can work to make the civil society be closer than the system to use better and expand how far they can go?
Thank you. And there was a question down at the end. And then we go back to the panel.
Hi, Brian Chung from the University of Oxford's Parliament's Rule of Law and Human Rights Project. I have a bit of a question, maybe a recommendation and then a question as well. And my recommendation concerns the implementation of and the compliance with the work of the treaty bodies, and trying to improve this. There could be more engagement with parliaments as well as other national actors like Maria and Helene have already mentioned, the national human rights institutions and civil society. That's very important, but it's also important to engage with parliaments. Well, unfortunately, the international human rights bodies have not really engaged with parliaments until the last decade or so as distinct actors. But you see a lot of efforts now within the Human Rights Council, where the council just held a session, a 2-day workshop in November of last year on parliaments as promoters of human rights, democracy, and the rule of law. And the Office of the High Commissioner for Human Rights right now is trying to promote the adoption of principles on parliaments and human rights, which the intention really is to strengthen parliamentary human rights bodies and their ability to then engage with the recommendations, the concluding observations, and the reports of the treaty bodies, and to then implement that and overcome the implementation gap that people always talk about. Now, currently, I only know of 2 treaty bodies that engage with the parliaments right now. The CEDAW committee has been perhaps the one that does the most, issuing a statement maybe in 2008 or so on engagement between parliamentarians, and CEDAW is always inviting parliamentarians to the sessions that they hold, along with other civil society actors. And it's also, there's a practice where the Inter-Parliamentary Union, the International Parliamentary Union, Secretary General writes on behalf of the Committee of the Rights of the Child and the CEDAW Committee, before a state is about to engage in the review process, they write to parliaments to let the parliaments know that this review is happening. And they also write to the parliaments to say, your parliamentarians are invited to attend the sessions, to engage with the recommendations that result from the sessions as well. But my question really is, what practices do your committees have to engage with parliaments? Do they have any previous current examples or previous examples? And my recommendation is that when the treaty body process has an outcome document, there should be strong mentions of engaging with civil society actors, national human rights bodies, and parliaments, because that would then enable the treaty bodies to then have the mandate to more legitimately engage with parliaments as distinct actors rather than just as part of the state delegations. Thank you.
Thank you very much. Alvaro, would you like to start?
Oh, do I have to address the one on migrants?
No.
From which side, Commission or the committee? Well, it's a tough question. From the side of the committee, we cannot address the issue. Well, considering the fact that the U.S. hasn't ratified the Convention on the Protection of the Rights of All Migrant Workers, but I think it might be very likely that at some point we might be addressing the impact of the agreements like the one that has been just subscribed between the U.S. and Mexico. In relation to the work of the Commission, and I thank Helen for bringing that point, the Commission has been, I would say, more creative, and I think that's something that I can say, considering that I'm kind of like in both systems. There's something interesting about the Inter-American system, and probably that's related to the historical lack of resources that has characterized the Inter-American system. But the bodies of the Inter-American system tend to be more creative, even confronting the lack of resources. When you go to Geneva, or probably when you go to international bodies that are not in the Americas, I'm not going to talk for Africa, you see that the procedures and the protocols and the formalities are very strong. Like, okay, this is our mandate, we work from this time to this time, this is all what we can do, and we cannot do more than that. At the Commission, it's like, if you have attorneys that are passionate and that want to work in something and are pushing for an issue, you know that you're gonna get that extra mile. So in that sense, I think it has been very interesting, because the Inter-American Commission has been trying to push like joint declarations with the Committee on Migrant Workers, with the Committee on the Rights of the Child, also with the Special Rapporteur on the rights of migrants, for example, on the migration crisis on the Venezuelans. And that's also in part because we are trying to harmonize and to break that fragmentalization that are between the standards that are developed by the Committee on Migrant Workers, the standards that are developed by the Committee, the Human Rights Committee, the Inter-American Commission. So like, for a field like migration, which is kind of like a new field in human rights law, because, well, we just started in 2003, and before that, most of the focus was on the protection of refugees under international law. There are many things that can be developed in a more coordinated fashion. In relation to the issues that you mentioned, like the separation of families in the U.S. Or the impact of the remaining Mexico protocols and the things that we are seeing at the border in the U.S., but also the externalization measures that the U.S. is pushing in relation to Mexico or Central American countries. The Commission has been addressing those issues through press releases. I suppose from last year to now, there might have been like 4 or 5 press releases in relation to those issues. At some point, it was like kind of very challenging to confront those issues because there was a new administration which has a stronger line in relation to migration. So it was a very sensitive issue to decide if we were going to address those issues and until what point the Commission was going to address it. But I'm glad to say that so far we have been like very responsive in trying to address and give some guidance in terms of the standards that should apply for those situations. We are also, and that has been kind of a challenging process, we have requested a visit to the border of the US with Mexico. The idea is that the Commission will be conducting that visit this year, and that will be like the third visit to the US border in 10 years. We conducted one in 2009, a second one in 2014 when the crisis of the unaccompanied children arriving to the border, and probably because of the separation of families and the zero tolerance policy and now all the policies that has been implemented since last year, we will be conducting another visit, I hope before the end of the summer. And as you know, because you both were part of the Commission, the idea is that after that, the Commission will be releasing a report on its finding on the site. Another issue that we have been considering in relation to this, and that's something that is a very important difference in migration issues with other human rights issues, is that this is the most transnational and international issue by its nature. Like every time you are dealing with migrants, you are dealing with situations that entails 2 or more states, the transit from one state to the other, the return, etc. So what we have been considering, and that might be an interesting sweep from the historical practice of the Commission, is to address this kind of situation, like doing visits to several countries, like for example in this case to the US, Mexico, but also to the countries of the Northern Triangle of Central America, and trying to have a more comprehensive approach to the situation, but also to the violations that are happening in coordination or with the joint action of the states. And on the point or on the question on the Global Compact and the Convention, I wouldn't say that there are like a strong difference between the content of the Global Compact and the Convention in terms of its substance. The preamble of the Global Compact, unfortunately, says that the Global Compact is based on the main human rights instruments like the ICCPR, the International Convention on Economic, Social and Cultural Rights, and other conventions, which is very unfortunate for us, considering that the Convention on Migrant Workers is the specialized convention for the protection of migrants. So we are just in the first, in the others now, in the note. But if you see the provisions or the 22 compromises that are in the Global Compact, I wouldn't say that there is a strong contradiction between these commitments that has been made by the states and the rights that are recognized by the committee. Something that we have been thinking lately, and it's a work that we will be conducting in the second half, well, we are almost in the second half of this year. It's to do a comparative analysis between the Convention and the Global Compact and try to find some interactions between these two instruments. Actually, in the concluding observations of Guatemala, Libya, Tajikistan, I cannot recall what was the fourth state, we have started to recommend the implementation of the commitments of the Global Compact in accordance to the provisions of the Convention. That's something that we have done with other kind of soft law documents like the global goals on development and so forth. Well, I will give the floor to my colleagues because I don't want to stand on that, and we can talk more about that. But at the end, I would also like to address some of your questions on how to make more accessible the the committees and the UN system, but please.
Thank you very much. Before proceeding, actually our time is up now. It's 9:30, 8:30, 7:30. 7:30. So can we continue for 10, 15 minutes? Because this, is that possible?
Probably 7 minutes.
7 minutes?
Yes.
Okay.
I don't mind hosting. So, yeah.
We do 7 minutes, but I think it's fair enough because Alvaro didn't speak very much at the beginning, whereas the ladies will now have a little less time to read. Yes, so we'll put things in balance. Yes. Maria Clara, please.
Well, I will only address your question about how the United Nations can make the civil society be more closer to the work of the committees. And I think that is an easy answer because the Inter-American system has a good practice that can be followed. When the court first started to have sessions out of Costa Rica, they do not only the sessions, but the sessions, the beginning of the sessions, there was a seminar on several issues about the functions of the court. So if a committee goes and has a dialogue with 1 or 2, 3 states in a country, then the whole session can begin with a seminar with academics in which they can explain how the system works and what are the obligations under that convention and the rights, and then in those sessions in the country, the court and the commission has meetings with judges, with members of the parliament, with journalists, with academics, and in those meetings there's also a way to disseminate the functions and the treaty body system, and I mean that's a good way of making the work of the committees closer to the people. And then after all that, there is the session, and all the people can go to the session. The dialogues with states, which is the thing that you can have in public, because the decisions are in private, but the dialogues with state are very long, are 6 hours. You can make some adjustments, like have part of the dialogue in public and the rest in private, but in order to have some sort of public thing so that the people can go. And if that is preceded by seminars and meetings, I think that's the practice, the good practice that can be followed.
Thank you very much. And Hélène, please.
Yeah, very swiftly, first on the question and remarks on parliaments, you are totally right. And it's a blind spot of the practice of the treaty bodies, because we, especially in the concluded observation, for instance, we address a lot of recommendation in order to implement, in order to improve the legislation, etc. But it's true that we never talk directly to parliaments, and it's a move we should have. You know, a lot of human rights organs always say that tribunals, domestic courts, etc., are the first human rights organ. But you are totally right. Maybe we should think also that parliaments are also a human rights organs, or maybe also a human rights tool in order to use. And so I totally take your recommendation. And on the question on what about the human rights, this World Human Rights Court? Yeah, it was a project. In 2011, it was a very ambitious project, but it was just a doctrinal project, and it's not anymore on the table. And I think, yeah, I agree. Fortunately, I mean, it's not the good moment. When states do decide to create an international tribunal, we need a special context. We need a special political context, etc. And we are in a very bad context. It's a context of pushback against different human rights bodies. So I think it's the worst moment to create an organ, because if states decide to create this organ, it will be a very weak organ, and I think it's not anymore on the table for the moment, and we need a political willingness also.
Thank you very much. We have 2 minutes left, and I will spend them because first and foremost, I'd like to thank the panelists and the audience. Secondly, I have some bad news and some good news. The bad news are that the treaty body system is seriously endangered. The forces that are let loose under a General Assembly review of the system will have all sorts of motives. Those motives will be to reduce the scrutiny, to avoid the scrutiny, to make savings of the system, to lump the treaty body committees into one, to lump the reports to the 10 committees into 1 or 2 maybe, to have 8-year reporting cycles of all committees, to merge it to the UPR, the political system. There are so many threats to the system. The good news are that for the first time the treaty body chairs have acted together. 2 years ago there were only a little understanding in the chairs, not to speak about the committees, about what this process actually could lead to. But 2 years ago we had a public resolution from Iceland and a few others, including New Zealand, who said, if you don't pull yourself together in the treaty body system and react to the requirements of aligning and working together, your friends cannot defend you. And that made the treaty body chairs to react, to start a process which has involved all the committees, which have involved meetings in Wilton Park in Copenhagen. I'm proud to say that it's Dignity that have organized these meetings. And now we meet later this month with a very fair chance of agreeing on a number of characteristics, also those we have discussed today, and to submit that to the General Assembly. And we have good reasons to believe that we will have support from the High Commissioner and the Secretary General. We're going to meet the Secretary General as well for what we can agree upon. And before that, we were not even a player. Now we are a relatively strong player. And that's the good news in an otherwise very dangerous process. That said, thank you very much to the Academy.